Mr. Fitzgerald, if I may first apologise for our late start. It was due to me being detained on certain administrative matters.
No, I'm sure.
We will adjust the timetable accordingly.
That's very kind of you, my lord. And my lord, because I know it was difficult at times for the court to keep up with the references, that we've set it out in writing what I'm going to say now, so that all the references are there. And I hope that assists. So, my lords, I said I'd say a few more words about the facts, and just to deal with those right at the start as a recap of the facts, really to show that the may well have been was fully justified. Lord Stevens made the point that real risk covers, as it were, a multitude of possibilities, from real risk, my learned friend saying 15% to real risk 49%. So what we're really showing is this was a very strong may well have been true, founded on a series of cross-corroborating statements from different sources. So the point we make at 1.2 is that each of the strands of evidence constituted separate and independent pillars. Firstly, the 1603 allegation of unexplained wealth and influence peddling, which you have set out in the summarised at page 47 of the SFI, where its investigation is set out. But if we look then to our case at 2.14, page 118, we there summarise what the evidence was, and it came from three separate witnesses: Dumitrescu, the nephew of Florian Purviu, Unguriano, who has subsequently died, and Dobrin, who worked there and who expressed his fears of possible reprisals if he gave evidence. These were provided in the context of a criminal complaint made about Judge Tudoran's behaviour by Mr. Panett. They weren't for the purpose of these proceedings, so that gives them an independent strength. And Dumitrescu confirmed his evidence in the Section 9 statement for these proceedings, which was served on the prosecution on the 10th of October. You'll see that set out in the case at 2.25. I won't, but you can see at 2.25, page 121, we set out that there was a witness statement. The High Court mistakenly said that there wasn't a Section 9 statement. There should have been. Well, there was, served on the 10th of October, and he says there, on the basis of what I saw myself, I declare and confirm that since at least 2002, and this is at page 365, when I came to be employed at Autovit, I observed and noticed that Floria Purviu, Judge Tudoran and Bacali were met regularly, talked, ate together and gambled, and they were very good friends. So that's separate evidence from Dojanas, quite separate from the nephew of Floria on that point. And then finally there's Dobrin, who confirmed his evidence in a Section 9 statement for these proceedings. Admittedly, we accept it was served very late, but when the criticism was made, and that's at paragraph 2.45, and the court will see there that he served a Section 9 statement. And he adopts his earlier statement. But whilst we're on the subject of Dobrin, it might be worth just pointing out that he does refer to his fears, and that's at page 5772.
Fitzgerald, I have some difficulty in understanding. Is this an appeal against a decision of fact by the High Court in relation to whether facts were established on the balance of probabilities?
Well, no, my lord. But what we do invite the court to do is to say that if one takes the two findings of the court together, my lord, that's to say the finding on the may well have been true about their statements, plus the finding in the very next paragraph that there had been no satisfactory answer, the conclusion that this court could draw on the basis of those is that it was satisfied on the balance of probabilities, and it is one of the grounds and one of the issues we defined in the SFI, my lord, that there should have been a finding on the balance of probabilities. My Lord, yes, to that extent, it's even if the test was balance of probabilities, it was satisfied in this case. But my Lord,
but would we have then to? Would your case be that the court below made an error of law in assessing the matter on a lower standard than the balance of probability, and that opens it up to this court? Would that be your position to look at it?
My Lord, it is an invitation to the court to affirm on other grounds. That's what the typical language would be, that we say, if the court concludes that the test is wrong, we invite the court to affirm on another ground. That is to say that even if the test is balance of probabilities, it was on the findings they made satisfied. That's how.
Yes, but in this case, the High Court has answered the question on the balance of probabilities. So would we then have to say that the court below was clearly wrong?
My Lord, yes.
Yes, we'd have to meet that standard.
Yes. Oh, yes. Or the alternative, my Lord, and this obviously would justify remittal, is if the court were to conclude, well, if you direct yourself that the test is only might well have been, and so you say, well, he's not going back because might well have been is satisfied, you don't ask yourself the correct question, if my learned friend is right, is it satisfied on the balance of probabilities? It needs to be remitted so that issue is addressed. My Lord Stevens, I hope that answers. Maybe not totally satisfactory, but I hope it answers your lordship's.
Thank you very much indeed.
Thank you. So then, operas. So it is quite important because my learned friend is characterising this finding as if it were just a 15% finding. One does have to look at the reality of what the finding at 162 came against, what background it came against. It came against the background which they recite in 162 of what their prima facie findings were, where might well have been is a pretty strong finding. I suppose if you say might have been, it's weak, but if you say might well have been, which is often used by the Court of Appeal when it sends a case back, for example, on diminished responsibility, might well have been a case. It's a stronger language. And if one's asking where in the spectrum from 15% to 49% is this, we say at the higher end. And Opris, then there was the complaint of Opris, which was entirely freestanding of the other witnesses. My lords, I took you to it yesterday, 2.36 to 2.39, pages 123 to 124, and we simply make the point that the evidence of Tudoran boasting about his legal assistance to Bacali with his purchase of the Stoya Sports Club and about getting him bail, it wasn't hearsay. And I give you the reference, it's page 393. He says he boasted to me that he'd got bail. Judge Tudoran boasted to me, Dr. Opris, his physician, that he got him bail. And so that's an admission, not hearsay, it's an admission of guilt in relation to perverting the course of justice. And it was never rebutted. And as to Dojana, there was Dojana's own evidence in his witness statements that he then adopted in his oral evidence. We've set out the High Court's summary of his evidence at 2.40. My lords, I'm not going to go into it in great detail, but you see there the summary of the evidence. And my lord, I think I'm missing a page actually for some reason. But without going into the detail, we just draw attention, for example, to the circumstantial detail in which Dojana describes the meetings between Bacali, Purview, and Judge Tudoran. And we've given you the reference 5655 to 5656 and 5661 to 5662. For instance, he says that Judge Tudoran and Bacali would meet at Purview's office and we were asked to leave. And then later honestly explained that he himself did not actually see them roll the dice at the backgammon encounters, but it was obvious that they were going into the room together to gamble. My lords, we've set that up, but again, if your lordships can just read those parts of the evidence and the very great details in operis. These are very substantial, detailed, circumstantial and specific accounts, so that the finding may well have been true, is amply justified and is a strong finding. And the High Court and the prosecution did make some criticisms about Dojana's evidence. They said, for example, that Dojana's came up, it wasn't in his witness statement, but he came up with the fact that the witnesses were frightened. Well, that wasn't something invented adventitiously at the time. It was something which was fully justified by the statements that there were. Can I just give you those? Dumitrescu, page 328 at the top. So in his statement, he talks about Judge Tudor.
Do you have the page number, sorry?
Page 328, my lord.
328.
328. It's at the top of page 328, and he says there that Tudoran was someone who kept threatening to put people in the ground, in the grave.
So where are you reading from?
Page 328.
Paragraph 3.
Paragraph 3.
Yeah.
Yeah. Yes, I'm agreeing. Yes. Yes. They stood up and he said, put them in the ground. He told us he could arrest anybody at any time, anyone, even on the street. So the idea that this was something ex improviso that he comes up with, there it was in the statements of the witnesses, that this was a menacing person, and there's a consistent pattern of that. And Dojana also said, Operis also talked about blackmail threats. Can I just give you that? That's reference 5609, and also in his statement, which is in the first bundle at page 391. And, my lord, we've criticised some of the High Court's findings as unduly favourable to the prosecution at paragraph 3.12, the obvious one being about no witness statements when there were. But we've set those criticisms out where they say we find it incredible that he only recently learnt that the appellant had been tried by Judge Tudoran. Well, this is a civil practitioner commenting on a criminal case. There's about, I think, 35 or 40 judges. If you asked a civil practitioner in this country who tried some notorious person, they might well not know. There's nothing incredible about that at all. They might say I was vaguely aware of some trial, but they wouldn't necessarily know who the judge was. And then the most strikingly point, which we've dealt with at Roman Free, we've made the point that there was ample evidence for Dojana to say that they were in fear. They had actually said that in the statements which he had presented. So there's nothing new or surprising about that. It's perfectly legitimate. So, my lord, the only other point on the merits is that Dojana, my lord, Lord Hodge asked me about the page 369. That's to say the bit about the closing of the case. And your lordships will see that it's there said, and my lord, you pointed out to me that it said it was decided to decline the competence to settle in favour of the prosecutor's office. And then I gave the court the reference of page 5681 B to C. And at 5681 B to C, one can see that Dojana, when he was giving his evidence, deals with this point. I'm so sorry, I'm just trying to get the exact passage. But when he deals with this point, he says the general prosecutor's case was closed, and he referred to the specific ordinance closing it. So it may have been transferred to the general prosecutor, but it was then closed. So this is not someone who was still facing charges, and you can see that at 5682. I know that it's mentioned in Panet's document the file against Dojana was closed in 2016. And then at 259 we see the reference to benefiting the publicity, and then it's closed. That's right. Yes. At 259 that's the ordinance. We see the reference to yes. So it was closed on the 5th of May 2020. That was closed, and that's just a fact.
So, I'm sorry, I'm losing you now as to the dates that you're telling me about.
Okay. Your Lordship,
There was evidence given by the prosecutor that the NDA transferred the file to the prosecutor's office. The NDA weren't taking it forward. You're now telling us that there is evidence here at 5682 that the prosecutor's office in turn closed the file.
my lord, that's right. So it was a bad point I took that there was not disclosure in 2016, but it is a good point I take that he was not someone that was closed. So that, in other words, to say that was his motive when it had been closed, or that the fact that he's facing charges should somehow render his evidence unreliable, is not right in the light of the fact that that was closed. My lord, that's a simple point I'm making in relation. My lord, I mentioned yesterday that Judge Tudoran's conduct in the civil proceedings, again, my lords, this is just simply to the question taken as a whole. Would this satisfy the test of balance of probabilities? I'll take it very shortly. 2.1, the relevant conduct is set out in Mr. Popoviciu's skeleton before the High Court, and that's at pages 508 to 509. It's only some entries in there. And, my lords, yes, you'll see it's really just if you take it from at page 509, 19th of September, Judge Tudoran's resignation became effective. On the same day, an order of the SIJ was issued stating Judge Tudoran was being investigated for offences carrying out commercial activities. Then on the 30th of October, the governing body of the Bucharest Court of Appeal determined that Judge Tudoran could no longer give the outstanding decision on the civil aspect. On 4th of November 2019, purported reasoning of the decision of Judge Tudoran was handed in, that's by his son, and then the purported decision was quashed as a nullity. So, my lord, that's the history there, and that's set out in the agreed chronology at pages 403 to 404. The court have that. And, my lord, we just simply make the point there that you can see in the various entries there that on the 30th of October, the governing body find that December 2009 decision could no longer be reasoned, i.e. it couldn't be given. And then Judge Tudoran's son nonetheless attends on the 4th of November with the written reasons. So that's the simple point we make in relation to that. And then the final point, my lords.
So when was Judge Tudoran told about all this? On the 30th of October, governing body decision.
Yes, my lord. So far as we know, he was informed then, yes.
How do we know that?
Well, my lord, I agree it's not in the chronology, but I accept that, my lord. But they quashed it because he'd handed it in without authority. My lord, the cutting and pasting, again, I can deal with this very briefly as at 2.2. A summary of the complaints of cutting and pasting from the High Court proceedings is contained at page 623. And your lordships have that at page 623 of the bundle. And a summary of the complaints of cutting and pasting there. And I can just give you the references. The reference to, as we have shown in chapter 1, is now at page 895 of the bundle. And then the part about the whole section.
So you've taken us to page 63.
623, my lord.
623.
I'm so sorry. 623.
So that's why I lost you.
No, I'm missing two, my lord. It's just there. It's Appendix B.
Yes.
And if your lordships see there's a reference to inappropriate of cutting and pasting, the obvious listing of passages, as we have shown in chapter 2, that's page 895. And then there's the whole section commencing chapter 8 is taken word for word from the indictment, page 894, and more generally hundreds of pages of indictment are transposed into the judgment. My lords, again, I can show you that very, very briefly. Two passages in the judgment which demonstrate that. You can see, first of all, the judgment at 877 to 8, and the court will see 877 halfway down. Does the court see, first of all, we mention? If you go down, it's the fifth full paragraph. First of all, we mention. Yes, and then at the bottom, we are making this statement, and then over the page, the third paragraph down, we are mentioning the fact. So it's clearly he's just posing, unless it's the royal we, he's posing as the judge, but is in fact just lifting page after page of what the prosecution indictment said. And you can see that even more clearly at 894, page 894 at the bottom, under the heading Chapter 8, as shown under Chapters 1 and 4, Part 1 of this indictment. So in his judgment, he is saying Part 1 of this indictment, unquestionably the land is part of the public domain. And then over the page, we have the passage as we shown in Chapter 1. So he's just lifting word for word, not even attempting to conceal the fact that he's putting it in we, because he's lifting what the prosecution have said and set out, and you can see that again at the bottom of 896. And just one final point, which is perhaps more substantive, which is at 1065, my lords, one sees he dismisses the defence case in, I think, 2 sentences. Page 1065, no analysis. Mr. Popoviciu had given evidence, but there's no analysis of his evidence or of his defence. He just simply says at the bottom of page 1065, none of the defendants admitted to committing any criminal act or to have broken any legal disposition. All the upholdings and the defences made are not supported by the probatory material, etc., etc., etc. The defendants did not prove in any way their claims, and the guilt which results from the assembly is certain and unequivocal. My lord, we say that to dismiss the defence case without any analysis like that is evidence, now that we know all we know, of a casual disregard of the rights of the defence. Moreover, there's no analysis at any stage of Bacali's evidence of the inconsistencies in it, or the fact that he only gave evidence once perjury charges had been initiated against him. So, my lords, that leads on to the point, against that background, we say, that the High Court, and this is at Part 3, correctly criticised the failure of the prosecution to respond to the allegations or to investigate the allegations. And as set out at Part 8, the law justifies the drawing of an adverse inference from such failure. My lord, we've given you all those references already. And English law is to like effect. That's the Petrodel case that I took the court to yesterday, about silence can convert prima facie into proof. So we say here the High Court failed to draw an adverse inference from the prosecution's failure to dispel any doubts. This failure amounts to an error to the prejudice of the respondent. If the correct test is proof on the balance of probabilities, then on the High Court's own findings, that test should be held to be satisfied. So, my lord, it seems that really is the point we're respectfully making, that we're seeking to invite this court to affirm on other grounds. And, my lord, this isn't something new. This is a point we took in our objections to the grant of leave. It's a point we took, and therefore it's one of the defined issues in the case right from the start in the SFI. There's been no secret of the fact that we take that point right the way through. And going back then, my lords, against that background to the correct test, can I now make my submissions as to why, in fact, substantial grounds for believing there's a real risk is the correct test, and we make the point. Firstly, my learned friend, for the first 45 minutes, as it were, delivered his so-called knockout punch, where he's going to sit down at the end of it, none of which appears in his case, but nonetheless, obviously we'll seek to deal with it. But he was saying that it can't be the right test, substantial grounds for believing there's a real risk that torture took place, or that the judge was biased, and he took paragraph 154 of the judgment, and he said it was plainly wrong what the court said, what the High Court said at paragraph 154, where the learned Lord Justice Holroyd says that they consider the test in Rostas as correct, substantial grounds for believing that there was a real risk. Now, as to the semantic point taken, we say there is nothing wrong with saying that in respect of past events. The test is whether there's a real risk that the allegations, be it torture or bias, are true, or whether they may well be true. It may be easier if one formulates it as they may well be true, because that is more apt to describe a past event. And as I say, it's sometimes used by the Court of Appeal Criminal Division about when they're sending a case back, they say, we think in the light of the new evidence, it may well be that the person had diminished responsibility or something like that. May well be true. And I don't want to split hairs, but I do say that that's perhaps a more helpful formulation, because it stresses that it's not just may, but it's may well be. It has some force. But in order to reach that conclusion, that there's a real risk, or that they may well be true, you have to have substantial grounds. So that's why you say we've got substantial grounds for believing that there's a real risk it's true, or that it may well be true. So there's only one test, the conclusion that there is a real risk or that it may well be true, but that conclusion must be founded on substantial grounds, or as in this case, credible evidence. That was the description at 162, that is not rebutted. So there's no, as it were, unfathomable legal fallacy there. It's simply saying that test should be now, my Lord, when Lord Justice Holroyd says, I've reflected on this and thought that the test should be the same test, I've put to the court yesterday, and perhaps I should have another run at it, this point. You can say in respect of a future event that it's likely to occur, meaning more likely on the balance probabilities. There's no semantic problem about saying it's likely that this will occur on the balance probabilities. Indeed, discretionary life sentences used to only be given if the court could conclude that it was likely, more likely than not, that the offender would commit further offences if set at large. And in the case of ex parte Bradley, that's said to be likelihood in the sense of it's more likely than not. Now, therefore, there's no problem about saying about a future event it's more likely than not, or there's a real risk. Now, what they're saying is, if it doesn't have to be more likely than not that the person will have an unfair trial in the future, it doesn't have to be more likely than not that he had a fair trial in the past, because you're trying to avoid in both cases the injustice of someone being sent back to the requesting state who may well have or may well have had a flagrantly unfair trial. And I limit here the test to, for the present purposes, to flagrant denial of justice, because it's such a great thing to say. It's saying this was a complete denial of justice. Now, in the case of Fernandez, which the court has, Lord Diplock justifies the real risk test for the future on the grounds of page 1682 following, on the grounds of the consequences. If you get it wrong, the person will have a seriously unfair treatment or be prejudiced on grounds of race, religion, and nationality. And he says, look at the consequences if we get it wrong and derive the appropriate test from that. And
whereabouts on page 1682?
My Lord, can I take you to page 1688, my Lord? Just from then on. So for my part at the bottom, it only leads to confusion to speak of balance of probability in the context of what the court has to decide under section 41C. It is a convenient and trite phrase to indicate the degree of certitude which the evidence must have induced in the mind of the court as to the existence of facts so as to entitle the court to treat them as data capable of giving rise to legal consequences. But the phrase is inappropriate when applied not to ascertaining what already happened, but to prophesying what, if it happens at all, can only happen in this case. So that appears to be an endorsement of the conventional, it's different when it's passed. But then if you look at the rationale, it applies equally in our submission. There is no general rule of English law that when a court is required either by statute or common law to take account of what may happen in the future, based on the likelihood, it must ignore any possibility of something happening merely because the odds on it happening are fractionally less than even. And then he gives examples about damages. You can look at 40%. So too, in determining whether or not to grant a quia timid injunction on the grounds that irreparable harm may be caused unless a particular kind of conduct is restrained, the court is not required by law to shut its eyes to the risk of irreparable harm unless it is satisfied it's fractionally more than 50%. The degree of risk would be an important factor in the court's decision. And then he goes on to cite 41C, which is may be prejudiced on grounds of race, religion, or nationality. The degree of confidence that the events specified in the paragraph will occur when the court should have in order to justify a refusal to return the fugitive is not determined by the mere use of the subjunctive mood. And then this is the ratio. It should, as a matter of common sense and common humanity, depend upon the gravity of the consequences contemplated by the section, on the one hand of permitting, and on the other hand of refusing the return of the fugitive if the court's expectation should be wrong. Now, exactly that applies. Those principles of common sense and common humanity. If you say, I'm 49% sure or 49% satisfied that he had a flagrantly unfair trial because the judge was corrupt and biased, but I'm still going to send him back because it's not 51%. Common sense and common humanity should be revolted at that. Just as if you say we're going to send him back and he may well have a flagrant denial of justice, but I can't be satisfied for the future that's more likely than not. That would be contrary to common sense and humanity. And again, Lord Diplock comes to, but judged by any of these tests or by applying, this is at the bottom, untrammeled by semantics, principles of common sense and common humanity, which are subsumed by the act. I can see nothing in the evidence in the instant case to justify that. So, my lords, I do seek, although it's not the only way we put the case, we do seek to justify the approach taken by the High Court at paragraph 154. Because why should the future risk of being detained on the basis of a conviction by a biased and corrupt judge without any remedy be any less of an injustice than sending someone to a country where he will suffer, or may well suffer, a flagrant denial of justice? In both cases, if you look at common sense and humanity and the gravity of the consequences, the magnitude of what's at stake, they are the same. In fact, they're probably greater in our situation, where you can actually say, this judge, you can actually look at it, it's not speculation, he may well have been corrupt. And so, my lord, that's our first point. And my lord, again, even if this test, this is at 4.3, should be modified or explained or refined so as to quantify the risk short of balance of probabilities more exactly, We say it could never be right that the court should disregard a 49% likelihood that the defendant was tortured or that the judge was biased in deciding there was a flagrant denial of justice. And yet that would be the consequence of the strict application of the balance of probabilities test advocated by the appellant, together with his corollary of the binary approach, fact or non-fact, 49% non-fact, 51% fact, disregard one, act on the other. And my lords, perhaps, and I know my Lord Stevens put this point, one of the troubles is we just don't quite know what real risk means or how may well have been it's got to be. But that can be put right by the court interpreting the test or laying down how it should be interpreted. But it doesn't, in this particular case, justify departure because it's quite clear that the may well have been was quite a strong may well have been. And amply justified as such. Secondly, we make the point, Hoffman is the only European case which goes into any detailed reasoning as to the test to be applied for the facts necessary to support a finding of a flagrant denial. The rationale for applying the real risk test, rather the balance of probability, is set out fully at paragraphs 274, 275 and 276. My lords, I took you to it yesterday. Can I just very shortly go back to those 3 points because my learned friend attached importance obviously to them. But if you look at them...
It's 2608.
Yes, exactly, my lord, yes. So you look at them. Firstly, the court does not consider the balance of probability as applied by the majority of lords as appropriate to this context. The point is that the context is very different from criminal proceedings, whereas in the present case, he might face a very long sentence. Well, these are criminal proceedings. That test is satisfied. Secondly, there's some conflict in the case law. Well, again, there is some conflict. Rostas takes one view, Lord Justice Holroyd takes one view, and then in the earlier case of Caderly, a different view was taken, and my learned friend says it's self-evident. We say not so. Then, thirdly and most importantly, the special difficulties. Now, my learned friend says it's all because of UNCAT, Article 15. UNCAT, Article 15, doesn't actually says it must be established. UNCAT, Article 15 says, can you just give it to me? Says you can't send someone back if it's established that they've been tortured. So it begs the question, well, what's the test of established?
UNCAT Article 15
yes.
is concerned with the admissibility of...
Yes, if it's established that the evidence, so it's, no one shall be subjected to torture, to cruelty. States parties 15.2 shall take all effective legislative, administrative, or to prevent person or from being subjected to torture or cruel, inhuman, degrading punishment. And then,
if you're founding on the precise words of UNCAT Article 15, do we have it in front of us?
Well, my learned friend was founding on it, and I'm just saying that's what it says.
Yes.
But my lord,
is it in the bundle?
I thought his point was a rather different one about the admissibility of evidence.
Yes.
And Article 15 says that such evidence shall not be admitted, save for the purpose of prosecuting someone charged with being a torturer.
Yes, that's absolutely right. But it says if it's established that it's obtained by torture. So it begs the question. It doesn't tell us what the test should be. You can't say, well, the reason why Hoffman was rightly decided was because of UNCAT. What you can do in our respectful submission is to look at the underlying rationale of those three identified points and then come to the conclusion. And my lord, if we go to paragraph 2880, therefore the court considers, this is at 2610, given the absence of clear evidence of a proper and effective examination, again, that's the fourth factor perhaps, there's not been a proper and effective examination of the allegations, and we say that the court actually made a finding in this case that there hadn't been a proper investigation of the allegations. So that, as it were, that finding is there. So three of the points at 2740 4, 275 and 276 apply, and 280. Now, if the law develops by reference to analogy an underlying rationale, then the same underlying rationale applies to this case. In fact, even more strongly, because the difficulties of proof are even greater. You can't see bias. You can at least see, as in the Hoffman case, one could see that they had been bruised and bullied. I mean, bruised and beaten. The question was, by whom? But you can't, because it's of its clandestine nature, this kind of corruption. And the idea that there isn't just as fundamental abhorrence under international law of corruption and bias as of torture is, in our respectful submission, questionable, because it undermines the whole fabric of the rule of law. And so, my Lord, for those reasons we say that the absence of a proper and effective examination of the allegations of torture is matched in this case by the absence of any investigation into the cogency of the separate allegations of the 1603 trio. And we know that because we've seen it in Mr. Miku's evidence supplementary bundle 3, that the Singe investigation seemed to have sort of run into the ground with resignations and then no further action. So, my Lord, that's the position. Now, then, can I then just briefly deal with Lison and Caderly, my Lords? Lison we analysed at 6.13, which is page 142, and the court was not at all convinced that the alleged unfairness was of flagrant nature, but the court then talks about the long-established general principles. My Lords, that's at page 1731. If it's established. Yes, Article 15, sorry, I'm so sorry, says...
what is it you're reading, 1731?
I'm so sorry, my Lord. My learned junior's just drawn my attention to the exact terms of Article 15. Would your Lordship mind if I interpose that? It's just one sentence. It's Article 15 says, each state party shall ensure that any statement which is established to have been made as a result of torture shall not be invoked as evidence in any proceedings. And as your Lordship, as my Lord gave me the except against a person accused of torture as evidence that the statements were made.
You must stay near a microphone. Because
I'm so sorry.
actually, there is a microphone there, but
I'll stay nearer to that. Yes,
it is recorded.
Yes.
Thank you.
Yes, but so you can't derive from those words of Article 15. Oh, that explains why in Hoffman they adopted the may well have been test, and why it shouldn't be adopted anywhere else, because it uses the word established. So the question is, how established? My Lords...
Well, I'm not sure if Article 15 will help us at all here, because no one is disputing the lesser test in the context of torture.
No, exactly. No, well, my Lord, no. My Lord, the question is... And again, just to make the point, the only cases really in which flagrant denial of justice, apart from when you don't hear the defendant at all, which I think is one of the Swedish case of somebody being sent to Lebanon, the only cases have been profound lack of impartiality or independence or torture. So if you're looking at what is at stake in a flagrant denial of justice case, it's these two situations. And why not say, well, if there's even a may well have been in relation to either of those, we are not going to send the person back. So that's, my Lord, the Lison and Caderly cases, 6.13, tab 7, yes, my Lord, that's at 1731 to 1732.
Was the Court of Appeal referring to the High Court referring to liaison?
No, it doesn't, my lord. No, I think Eleshmawi they were referred to Eleshmawi because what happened was initially, my learned friend's quite right. Initially, we said the balance of probabilities test is satisfied. Applying Eleshmawi. Then the Ross test case was drawn to their attention, and we said, well, there's an argument that the test is actually more generous, and they adopted that more generous test. But Eleshmawi was certainly addressed to the court, but liaison was not, I don't think, my lord. But liaison paragraphs, if you look at pages 1731, it's the reasoning of Lord Justice Aitkins. Because the trial and appeal process has already occurred, it constitutes past fact. Thus, the question of whether it was flagrantly unfair is susceptible of proof. In our view, in a situation such as the present, it is for the appellant to establish on the balance of probabilities. I know the fact that it's short doesn't mean it's not of value, but there isn't a reasoning as to the alternative view. And of course, this decision was it doesn't refer to Hoffman or the other approach at all. And the long-established general principles are clearly principles which certainly are well established in civil cases, but it's questionable whether that's always the approach in criminal cases, where there are many examples where you just have to raise an issue and then it's for the prosecution to negative it, or if there's a legitimate grounds for fearing, the prosecution have to address those grounds. So that's the liaison case. Then there's Kederli, which does contain a detailed reasoning as to why the test should be the balance of probabilities, and that's at 1704, following it in the key passages. I think I can take you straight to paragraph 51 at page 1717, my lords. The concept of real risk, this is at 51A. He must establish that his trial was flagrantly unfair at the top. And then A, the concept of real risk is generally used in a forward-looking sense to refer to the probability an adverse event which has not yet occurred will occur in the future. When addressing the standard of proof for establishing how likely it is that something happened, other concepts such as proof beyond reasonable doubt, proof on the balance of probabilities, or reasonable suspicion, or we'd say, or it may well have happened, are generally used. That was the phrase used by Lord Justice Sedley in the case of Ramda, and as I say, it's often used by the Court of Appeal Criminal Division, may well have been. This usage, it seems to accord with the language of the Strasbourg Court in Suring, case which established the real risk test in extradition, has suffered or risks suffering a flagrant denial of justice. This suggests a dichotomy between cases where it was in the past and where it's feared in the future. C, this is consistent with the language used in subsequent authority of the Strasbourg Court, and then it cites Drozd. And can I just take those A, B, and C first of all? We say the case law does not always, this is at 6.14.1, case law does not always use the balance of probabilities, see Hoffman. And in relation, and then at page 143 at the top.
So this is, you're referring to your
yes, this is our response to those points, my lord. It's 142 at the bottom. It's not right that the case law always uses the balance of probabilities for past events. Secondly, in relation to 51B, the quote from Suring simply...
The first point, is that the only example you can find?
Well, there is Ramda where they use language, but that was again an allegation of mistreatment, where Lord Justice Sedley used the expression may well have been subjected to torture, and then said that if there's no remedy, then that combination would satisfy the flagrant denial of justice test. But, my Lord, yes. But of course, Hoffman is the only case that's ever succeeded, and it's the only case where there's a detailed analysis of this point. And in relation to 51B, the sentence inserting has suffered or risks suffering simply demonstrates the European Court was aware that the flagrant denial can be both based in history and in the future. Decision doesn't deal with the standard, and the use of the phrase has suffered does not preclude the application of a real risk test. Indeed, in Hoffman, they said it had been established, although it had been established on lower test of real risk. They used the language of has been established. And then in relation to 51C, the word is in Drozd is too slender a basis to deduce a doctrine as to the standard of proof. In any event, the use of the word is does not preclude the application of a real risk test. In the end, in Hoffman, when they said he'd satisfied the only test that would be fair to apply to him, they said it is established. So, and then the same point goes for 51D and E, the reliance on Uller and El Ashmawi. Then if we look at paragraph 52, that refers to the case of Sobchak, and my Lord, can I just, I think there's a bit of confusion in my drafting there. As to 52 of Kaderli, it suggests that it would be, can you just cross out cited decision and this suggests it would be necessary to establish the basic facts relied on for bias on the balance of probabilities, and then it should be rather than subject, if you cross out subject and put para 52 of Kaderli, quotes from Porter and McGill, which requires the court to ascertain the relevant circumstances. And then, my lords, you know our point is, well, the relevant circumstances here would include the fact of criminal investigations and the fact that unanswered allegations of bribery and corruption have been made, where one would expect answer to be given. In other words, the relevant circumstances is wider than just determining facts on the balance of probabilities. Therefore, the notion of a binary fact, which is either true or not, is oversimplistic. On the balance of probabilities point, it's also the burden of proof. It's inconsistent with Merabishvili, and my lord, we would say that Pierce also recognises very clearly that there is no inflexible rule to justify a binary approach in all circumstances. I'll take the court to that. And then in relation to paragraph 54 of Kaderli, statement that the European Court would require that an applicant must establish that occurred not merely a real risk, that's questionable in the light of both Hoffman and Merabishvili. And we make the final point that they never really had to confront the issue where it actually made a difference, because they thought that the real risk test itself wasn't made out in 6.17. In other words, at paragraph 57 of Kaderli, they said, well, the judge, Mr. Justice Chamberlain, said that even if he'd applied the lower test, it wouldn't have been satisfied. So, it does make a bit of difference whether you're actually confronting it. Am I going to send someone back where I think there's a real risk in the sense of may well have been, or where you say, Obiter, well, actually, I don't think that test would be satisfied anyway. My lords, you have the point at 4.6 about the magnitude of what is at stake. We've analysed that at paragraph 5.17, and I've taken you to the case of ex parte Fernandez, shown how a great part of the underlying reasoning could apply equally to a past event. My lords, then the next thing is Pierce. We have that in the supplementary bundle, and I know your lordships were, is that supplementary bundle 1, is it?
Should be supplementary bundle.
Which one?
1, yeah.
So it shouldn't be supplementary bundle 3, it should be supplementary bundle 1, I apologise.
Tab 10, I think, page
yes.
53.
Yes, would your lordships just give me one moment to sort myself out? But Is it at 63? Yes, my Lord. So at page 49, the Pierce case starts. Can I just draw attention to two passages? Firstly, at page 75, paragraph 44, I just quote the finding. We consider that the observations of Lord Slynn and Lord Hoffman, which we have quoted, support the view that a decision maker, whether the member of the executive body, branch or government or a judicial body, when assessing future risk, is not as a matter of law compelled to have regard only to those facts which individually have been established on the balance of probabilities. Decision maker, from the assessment of the evidence as a whole, can take into account, alongside the facts which have been so established, the possibility that allegations which have not been so established may be true. Now, if you're thinking in terms of the Article 5 ultimate question, will he be subjected to arbitrary detention, then a combination of may well have been and there's no remedy could fit into that analysis. That's to say, the reason why he will be arbitrarily detained is there's evidence that he may well have been tried by a corrupt and biased judge, and there is no remedy. That, added together, leads to a future risk of arbitrary detention. And, my Lord, I would say arbitrary detention under Article 5, not just 5.4.
Pierce is in a slightly different circumstance. In Pierce, this court was looking at the risk assessment by the parole board of the possible future behaviour of a prisoner.
Yes.
Here, the prospect of arbitrary detention depends entirely on what had happened in the past. One is not having to assess what someone will do in the future. One can assume that if your client is sent back to Romania, he will be put in prison. The arbitrariness of that depends entirely on the case made about the inadequacy and corrupt nature of his trial.
Well, my Lord, I certainly accept that there's a distinction, and I don't want to force the paragraph 44 analogy too powerfully, but it is the combination, in our respect, for what makes it arbitrary is the combination of he might well have been tried by a corrupt judge, and there is no remedy. There'll be no retrial. So if you look at those two together compendiously, and you ask yourself, if we send this person back, is there a real risk of substantial grounds for believing there's a real risk his detention will be arbitrary? We would submit, yeah. And it doesn't just depend on Article 5.4. It's about... Oh, sorry.
No, you're fine. Carry on.
Okay, thanks.
Ignore me.
I would never ignore you, yes. So that's the position. But, my Lord, perhaps of more assistance, because my Lord's judgment at paragraph 65 helpfully sets out some general propositions. At 65.1, Lord, having set out at some length our reasons for rejecting the suggested existence of a general principle of law that the law knows only the binary concept of fact and non-fact, we summarise our conclusions from the cases which we have discussed. And then this is important. One, as a general rule, I underline the words general. In civil proceedings, I underline the word civil, facts in issue must be established on the balance of probabilities, and the binary approach of fact or non-fact is to be adopted. We say it's only a general rule, it's obviously subject to exceptions, and this is one of them. And it's a general rule in civil proceedings. Hoffman shows the importance of the context of criminal proceedings. It was the first factor highlighted in paragraph 273 of Hoffman. And therefore, that we do attach significance to it. And then it goes on to look at how material can be cogent if taken together. And of course, we are saying that as to the future risk of arbitrary detention, there are a number of factors which, taken together, make it arbitrary. And those include the lack of an investigation and the lack of a remedy, as well as the finding that it may well have been. So, my Lord, we perhaps really it's 65(1) that I'm majoring on, as it's only a general rule. It is clearly subject to exceptions. It is in civil proceedings, and is against the background of the very careful and considered decision that there's no general principle of law, that the law knows only the binary concept of fact and non-fact. So, to the extent that my learned friend or the appellant puts forward the proposition, there is no other alternative. There's either fact or non-fact. That is throughout the law. We say not so. Pierce actually makes clear that it's dangerous to talk in those terms of only knowing the binary concept of fact or non-fact. And it leads to, in this particular context, the unjust result that, I'm maybe labouring the point, but 49% convinced would not be enough to stop extradition. Now,
I'm just wondering, Mr. Fitzgerald, as to the difference between a conviction arrest warrant and an accusation arrest warrant. An accusation one, you wouldn't ordinarily get a situation arising where someone's complaining about the fact that they might be tried by a particular judge, because you never know which judge is going to conduct the case. But I suppose that might arise. You'd still be relying on past facts in relation to an accusatory warrant if you knew that it was going to be a particular judge.
Yes, you would.
Yeah. Well, then you would have coherence between the two, insofar as past facts would apply to both accusatory and conviction warrants, both being established in the balance of probabilities.
Well, my Lord, yes, but so you mean if you said I may be tried by this judge,
if you say this judge always hears all the cases in this particular area, I'm going to be tried by him and he's corrupt, and I can establish he's corrupt because of A, B, C, and D that has occurred in the past.
Yes. Well, my Lord, your Lordship's example is actually much nearer the truth than you. For instance, in the Russian cases,
yes,
there was evidence that all the Khodorkovsky associates were going to go back to the Moscow City Court,
yes,
where the particular judge had a record of being, I mean, it's in the judgment, yes. I'm not abusing it, it's in the cases, had a record of always convicting. Yes. But my Lord, nonetheless, I'm not sure that the judges did deal with that. I mean, they said there is evidence this judge, who is likely to try this case, is unfair. I don't know whether they were quite that programmatic as to say, and I find on the balance probabilities that she is unfair, rather than just saying there's evidence that she may well be, or, I mean, in other words...
perhaps they would be a bit diplomatic about it.
Well, my Lord, that's a fact, my Lord, which may be significant. The reason why the courts often say that we'll only say there's an appearance of bias at stage 2 rather than there is actual bias is a kind of judicial reluctance to undermine the reputation of a serving judge. And so it says, well, we just deal with it in terms of appearance of bias. And my Lord, that's why it may well have been, maybe on grounds of policy, more apposite in cases like this, rather than making a finding on the balance of probabilities. But my Lord, I mean, they are referred to in that passage from Netezerayo, paragraph 88 of Netezerayo, which we've referenced in the case. Some of the cases about return to the Moscow City Court are referenced there. So, well, then I've got to deal with the, well, my Lord, it may be, I regret to say, something of a damp squib, But I did raise the issue about juries, and my learned friend has come back with a series of cases about Ouija boards and all that, where it would appear that there are dicta saying you've got to find out the facts. But did the court get that case of Brown overnight? Was it sent in? I think it should have been sent.
Is this something that's been lodged today?
I think it may have been lodged yesterday.
With your summary of submissions, 1001.
No, my lord, it's a case. Well, we refer to the case of Brown in that, but I think it was
It's separate.
Yes, it's a separate thing. My lord, has it not come through?
It has.
It has.
Brown, the case of Brown.
There's something. The Brown came through after 10 o'clock this morning.
Oh, I'm sorry. Is that a cut-off point? Or?
That's the Queen against Brown. Yeah.
Yes, my lord.
We have that.
I'm very grateful. Okay. Well, my lord, I'm going to put it no higher than this. That it's quite difficult to find one's way through, but there was the allegation of that the jurors had heard remarks being made by the family of the defendant, and the question was what had happened and what effect did it or might it have had on the jurors. And can I just give you the reference at paragraph 36? Secondly, even if the appellant bore some responsibility for what was said or done, there is no basis, even on the jurors' statements, for treating what happened as the appellant's primary responsibility and as involving either a deliberate attempt by anyone to derail a jury trial. So it's even on the jurors' statements, it's not. And yet the general impression given by the statements is they viewed what happened as a collective response of the appellant and those with him. So it doesn't go...
They found on the balance of probabilities that was what the jurors felt.
The general impression?
Yes.
Well,
that's right. And then they had to decide what to do about it. And so
that's why I prefaced it with a damn squib point.
Right.
But it doesn't seem to be a definite determination.
And at paragraph 28, they applied the standard two-stage test.
Yes.
Or set it out anyway.
Yes, so the relevant, yes, the relevant, but, well, your lordships have my submissions about relevant circumstances. They may be right, they may be that there is an allegation has been made and it's not been responded to, rather than we find that this happened. But, my lord, that's the point we made in relation to Brown. The Irish authorities, can I just deal with it? I think I can deal with it as per the note. There's no doubt that Marjaz, as my learned friend has shown, referred to the test of clear and convincing, and Rostas refers back to Marjaz and says it requires modification in the light of Hoffman. Can I just take you then to page 2891 and to the case of Rostas. You have it, it's tab 28. If we go to 2891, one sees that, as my learned friend took you to, paragraph 91, they set out Hoffman and the real risk, substantial grounds for believing real risk. He does not cite paragraphs 273 to 280, but clearly he has regard to the judgment in Hoffman, at the end of which they do adopt a test of might well have been, or may well have been. And he says then at paragraph 92, and this is about the third sentence in the statement about requiring clear and convincing evidence, that statement requires modification as a result of the decision in Hoffman, to the extent that what must be established is not the actual unfairness of the trial process leading to conviction, but rather the establishment of substantial grounds for believing there's a real risk that the respondent suffered a flagrant harm. Now, in the end, that is what they were saying, that substantial grounds. The issue of fact was, were these people tortured? And the finding was a finding made on the basis of may well have been tortured. And that, in our respectful submission, for the reasons set out very fully at 273 to 282, as to the approach to be taken where a trial, where a finding of fact takes place in the torture context, is appropriate. And then you see at paragraphs 111 at page 2895 that they apply that test and say it's impossible to form any view as to what events described actually occurred, and impossible at 1112, impossible for this court to form a definite view as to whether the trial was conducted in the manner described. But then 113 inclined to attach some importance to Butuk's opinion, and so it's a bit tentative, I accept, in the application of the test. But then one sees, while the 115, while the evidence of Mr. Butuk cannot be regarded as corroborative of the respondent's account of her trial and the manner in which she was represented, it does provide significant supporting evidence in the sense of indicating her account is consistent with his own experience of how such cases were dealt with. And then just going on lower down, that moreover, when speaking of possibility, the court is not to be taken as merely acknowledging a remote or theoretical possibility. On the contrary, the court considers the available evidence, notwithstanding its incompleteness and all its inadequacies, is nonetheless cogent and raises a real and significant concern that the respondent may not have had a fair trial. So we say that is an appropriate approach in the light of the Hoffman reasoning at 273 to 282, and that then it makes the point also that there was no rebuttal. The court, you see, it refers to Marjaz there, and previously referred to, I was expressed the view that with respect to requests for rendition on foot of a European arrest warrant, that the rebuttable presumption arises that any conviction was the result of a fair trial, but he says that here that has been rebutted, and the court, having therefore been put on its inquiry, finds that its concerns have not been alleviated by any additional information from the issuing state. End of inquiry, having substantial grounds for believing there's a real risk. Well, all that means is he may well, or sorry, she may well not have had a fair trial. Now, there might be a dispute.
It's an unusual formula to rebut a presumption by something less than proof of the contrary.
Well, my lord, I'm not.
But you only have a certain amount of time. I won't take you up on this.
Thank you, my lord. Well, then, okay, then, my lord, my submission is that Rostas, even if one could quarrel with all the reasoning, it does indicate that there was a need for a modification of the clear and cogent evidence test, or compelling evidence on the balance of probabilities test, in the light of Hoffman. My lord, the next point that we deal with is the no remedy point, my lord. Did your lordship say I have until 12:10? Is that?
No, you because of the late start, you have another 5 minutes.
Oh my God!
You have to 12:15.
To 12:15.
Yes.
My clock says it's 10 to 12.
Yes, that's
It is 10 to 12.
So I've got 25 minutes.
Yes.
Oh, that's all right. That's okay. Oh, sorry. I thought you said another 5 minutes. I'm sorry, my lord. I'm sorry. I nearly had a heart attack, my lord, and I've only taken one beta blocker this morning, so
I would not wish. I would not wish to disturb you with my words.
Yes.
So you have to 12:15.
Yes. Okay. So, my lord, the no remedy point. The appellant has always taken a separate no remedy point. My lord, I'm not going to go. I took you through the notice of objection. It was taken, however imperfectly. I mean, the question about no remedy, it can be formulated in Article 5.4. It can also be formulated in Article 6 as no access to the court to put right and injustice. And my lord, if you look at the whole history of both the UK system and the Commonwealth, which has imitated us in this respect, in every jurisdiction there is a mechanism where after the exhaustion of the normal appellate procedures, the case can get back to the court, either through the Home Secretary from 1907 to 1995 or the CCRC, and where the decision not to refer the case back to the court is judicially reviewable. That's throughout the whole of the Commonwealth, which has adopted the system. So the idea that there is no mechanism to get back a suspected miscarriage of justice after the completion of the normal appellate process, where new evidence casting doubt on the safeness of the conviction in a fundamental way arises, is, in our respectful submission, anathema. Now, that's our point. You've got to either have access to the court, Article 6.1, where there's a suspected miscarriage of justice, or if a new issue affecting the legality of detention arises, see Etute and the other case, that you've got to have a mechanism for addressing that. And that's the way we put it. My lord, it may be that this is a novel point, but it's a fundamentally important one in our respectful submission. And we say, with great respect to my learned friend, that it's simply wrong, this is at 5.2, to say that all parties are agreed that there is a remedy. Professor Chiritza expressly takes issue with the existence of any practical or effective remedy. I reminded your lordships of...
I do apologise, Mr Fitzgerald, but you quoted Etu and another authority.
Yeah, Etu, yes.
In relation to Article 5.4.
Yes.
And you've said, well, it can also be analysed under Article 6. Is there any authority?
My lord, I can't find we couldn't find a case on Article 6. It's just on. I'm afraid we have to go back to first principles. That in the case of Sims and O'Brien, Lord Stane talks about the importance of having a mechanism through journalists can raise an issue of miscarriages of justice, as it were, not to let them stand. And we have put in, I think, in the supplementary bundle, the thing about a general statement about. Of Justice Dean, a conviction which has been obtained in breach of the rules of natural justice cannot be let to stand.
Where are you now?
What is this?
My lord, it's in the supplementary bundle.
Which one?
It's in supplementary bundle 3, my lord. And it's...
Page?
I think it's page 101, my lord. Yes. Yes. The central paragraph 4, the central prescript of our criminal law is that no person should be...
You have to bear with me a moment. I think
I'm so, forgive me, my lord. 101.
This is the judgment of Mr. Justice Dean.
Yes, in the Diedrich case.
In
Jago. In
Jago.
Yes. That's a famous case on abuse of process. But my lord, I'm just taking the dictum out of it because it seems we did look for the opposite. A conviction cannot stand.
Bear with me a moment. Which case is this?
This is Jago, my lord.
Yeah.
Jago starts at page 82. Jago in the district court, my lord. And then at paragraph 4 on page 101, my lord. It's just one sentence. Sorry. Yes. You mean the central prescript?
Which is the sentence?
It's a central prescript of our criminal law is no person should be convicted otherwise than after fair trial. A conviction cannot stand if irregularity or prejudicial counsel has permeated or affected proceedings to an extent that the overall trial has been rendered unfair. Is there another sentence?
Sorry,
Yes, that's okay. Oh. Yes, sorry. Yes, but it's that if a conviction cannot stand.
Thank you.
Yes. So, my lord, it may be that the reason we can't cite cases is because the UK system, the Commonwealth system, does provide a remedy. And of course, there are cases where, and there's a famous case of Christy Walsh in Belfast, in Northern Ireland, where the CCRC, having refused the court, did it by way of relisting. But the idea that there must be a remedy, ubi ius ibi remedium, where there is substantial evidence that a conviction is wrongly reached because of, in this case, corruption and bias, is, we respectfully submit, so fundamental that the court can, out of its own breast, as it were, develop that principle or state that principle. It is a fundamental. I mean, the Article 5.4 cases are where some new development breaks the chain of causation between the original conviction and the continuing detention, and they could be adapted to deal with that situation. And your lordships have those cases. But what we respectfully submit is that whether it's under Article 6, access to the court to correct a miscarriage of justice, or under Article 5.4, there must be a remedy. And what we have, can I just summarise what we say? First of all, they said there is no remedy for the relationship. And that was the position right up until, I think, the 27th of March of this year. No remedy. Then they said, well, there may be a remedy under 4531A, and Professor Chiritza showed that that simply couldn't apply because you need new facts showing innocence. They also relied on 4531D, and he showed that that requires a criminal conviction beyond reasonable doubt, which was as to perverting the course of justice in the case. That's quite different from the fact that the non-disclosure of a relationship has infected the case with fundamental.
I don't think you need take time showing that there is a bona fide dispute as to whether there is a remedy.
Okay.
I think I've given a fairly clear indication that the court isn't going to rule on that matter. If we go back to the case of Perez, on which
Yes.
on which the Crown has relied, there the ratio appears to be based on an earlier case of De Wilde, Ooms and Versip against Belgium, that where the court that has pronounced the conviction, where the sort of detention is based on a conviction in a court of law, that of itself meets Article 5.4. But your case, as I take it, is that, well, what happens where there is a strong suspicion, if not higher, that the judge has been corrupt, and further evidence is coming to light on a regular basis. What happens if the receiving state offers no remedy to the court, to the convicted person in those circumstances?
Yes, my lord, that's it. I mean, De Wilde, Ooms and Versip just states a general principle that the original conviction justifies detention throughout. Then you have the series of cases about, well, where some new factor breaks the chain of causation, such as conditional release, see Weeks and all those cases.
Yes.
and they say, well, we have to qualify that. It's not exactly this case, but we do say that if some factor arises which suggests that the conviction should not, if examined by a court, would not continue to justify detention, there must be a mechanism. Now,
yes.
My Lord, that's why originally we put it under Article 6, access to court to correct miscarriage of justice. It can also be formulated under Article 5.4.
Yes.
But as, my Lord, I know your Lordship's given a very clear indication, and I abide by that the court's not going to decide the issue of whether there's a remedy.
Yeah, I mean, if you have a case under Article 5.4 or 6.1, given that there is this dispute, it seems likely the court might have to consider a remit back to the High Court to hear evidence on that.
My Lord, and that's what we've said. We said
Yes,
but
but what we haven't been given so far is very much authority on the application of Article 5.4 in this context. Now, there isn't obviously time this morning to go through that, but I think the court would be assisted by a short note from the parties on the qualifications in Strasbourg case law on the Teverlungsempfängnis general principle.
yes, and on Article 6.1 access to, my Lord, yes, because that's the...
Because if we are considering the necessity of a remit, we would need to have that case law in front of us.
Well, I respectfully submit that as to Perez, that is entirely distinguishable. We've dealt with it at 5.5. It's not like this a case where it was being suggested a decision in the extraditing state could provide the necessary review. The High Court were not purporting to carry out an Article 5.4 review in this case, and nor did they have the full powers of a court conducting such a review. They couldn't, our court couldn't order discovery because there's no power to order discovery, and they were operating on the basis that all evidence will only exceptionally be heard, so that originally they even refused to hear any witness, even Dojana. And so we say that Perez, and in any event, the High Court in this case were applying the flagrant denial of justice test. So it's impossible to say that the High Court, conducting the exercise it conducted, has dealt with the question definitively of whether there was a miscarriage of justice in this case. What they've done is to say that on the materials before them, exercising their limited jurisdiction, there may well have been a flagrant miscarriage of justice.
Yes.
And we say that begs the question, well, what's going to happen about that now? According to the Romanian government, right up until the 27th of March, nothing. Now...
Well, again, I wonder if you need to take your time up.
Sorry, my Lord. Okay,
for the very reason that we are not going to rule
no, you're quite right, my Lord. Okay.
those matters.
I apologise. So then the final point is the case for remission, which obviously follows on to some extent from what your Lordship has made. So if the court upholds the submission that the wrong test was applied, and obviously you have our submissions on that, and if it does not uphold the respondent, that's to say our submission, the balance of probabilities test is in any event satisfied on the High Court's own findings, then we submit that remission is the only fair course of action. And that is for the reasons which we've set out at Part 11 of our case, at pages 156 to 157. And, my Lord, I can just... You have it set out there, but I can summarise it very briefly. We say, firstly, that the respondent should have an opportunity. I mean, there's no doubt about the jurisdiction, see Norris. But firstly, we say, if they applied the wrong test, and this court then says what the right test is, we should have an opportunity of persuading the court by reference to the correct test, where the court is actually confronted with the situation that if they find it's not satisfied, they will actually order extradition on the basis of the correct test. I mean, it's just really that a decision needs to be a decision with full regard to the consequences of that decision. Secondly, this would afford the respondent an opportunity to correct some of the errors to his prejudice made by the High Court when they reached the conclusion that the balance of probability test was not satisfied. For example, they found unsatisfactory that there were no Section 9 statements from Dumitrescu and Dobrin, but in fact there were. And they made a number of findings about Dojana's evidence, which my learned friend will say justified, but which we've set out our reasons for saying went too far. But thirdly, and furthermore, there is new evidence summarised at Part 4 of the Respondent's case, and as to that new evidence, Dr. Opris' Section 9 statement strengthens the evidence contained in his original complaint. In his original complaint, of course, he wasn't looking at this case at all. He was complaining. But then, when focusing on this case, he's been able to now give a Section 9 statement which focuses on the Bicali-Tudoran nexus and deals with the point that he actually saw them gambling together. And he's made it clear that he would give oral evidence. And remission would enable the court to also assess the significant new evidence of Andronic and Bosdoro. It wasn't available for the High Court, but for the reasons given by Mr. Dubé in his detailed witness statement at page 5387 and in particular 4841 following. As is a
Page 5, in particular.
4841, my lord. So 4841. It should be 5841. Supplementary. Sorry.
4841.
Yes. Well, essentially, can I summarise, and your lordships can see what he says is the first notice in relation to it was when 3 weeks before the appeal hearing, Andronic gave a television interview, and that's at 5841. I say it's 5841. So it's 5841. And 5841. And he deals with it there at paragraph 15. He appeared as a guest on a Romanian television show and disclosed the allegation he had paid a bribe to Judge Tudoran. Then statements were taken. Miss Pizlaru received a copy of a criminal complaint made by him to Sige, in which his detailed allegation against Judge Tudoran of 17th of March 20 was produced, but when we got that, it was the third day of the appeal of Mr. Popoviciu. It was not possible to serve evidence of these new allegations against Judge Tudoran in the High Court, given the very late stage in which the new evidence arose. The complaint made by Mr. Andronic to Sige was provided to Ms. Pizlaru on 17th of March 2021, the third day of the 5-day appeal hearing. Not possible to obtain an English translation to allow us to understand the contents, assess their relevance, and apply to the High Court for the admission. So, my lord, that's the position. His statement, of course, you have at pages 5860 and at page 5860 he refers to attending gambling sessions with Bicali and Tudoran, and over the page he deals with a bribe given to Justice Tudoran by himself to secure a better result. That's dealt with over the page at 5861 in the two full paragraphs. And my lord, I'm not going to enter into the arguments or a detailed analysis of that evidence. I simply say it is significant evidence, both Opris' further statement, which closes gaps that there may have been in the evidence and further corroborates, and Andronic and Bosdoro's evidence. As I understand it, if it was called, it would be contested at any remission. my Lord, what we say is the fact that the wrong test may have been applied, you can't just simply say, well, let's take the finding that it wasn't established on the balance of probabilities and send him back. That's just not looking at the thing in a fair way, where the court is actually saying, well, we'll apply the right test and it's not satisfied.
This is potentially relevant in two ways. One is your wider point that you want to remit back, if we think the High Court erred, a remit back on the merits. But separately from that, if you're right that the Convention requires a remedy if new evidence comes to light, even if the conviction by the court, on the hypothesis that it was a fair trial, would provide the necessary Section 5(4) requirement. You are saying, I think, that you want to remit back to the High Court to ascertain whether or not there is a remedy available which would allow Mr. Tudorand, if he were to be sent back, to bring before a judicial tribunal in Romania the evidence that he is assembling.
Yes. My Lord, is in the absence...
That is your submission, isn't it?
My Lord, we would say it'd be a flagrant denial of justice to send him back if there is no remedy, and there is no remedy, but as your Lordship says, the opportunity to at least... it seemed easy because they said there was no remedy, but now they've said, well, perhaps there is a remedy. We respectfully submit that we must have an opportunity to establish that there is no remedy.
Yes.
And that in the absence of that remedy, this would be the very definition of a flagrant denial, that there's
yes. So even if you were wrong on the substance of the appeal, you would say the absence of a remedy in relation to new and emerging evidence is itself a reason for not sending back?
Yes, it would be a flagrant denial of justice not to have some mechanism, and the evidence is there isn't some. And my Lord, the European Court thing, just to clarify the point, that there has been an application put to the European Court as earlier. We've set it out at paragraph 5.6 at page 8 of this note, and that was drawn to the attention of the district judge and recorded in his judgment at paragraph 495, page 290. It was common ground before the High Court. The problem is that case, there hasn't even got to a decision on admissibility. It's just pending. We can show you the screenshot of its status at present. So that remains outstanding, and one can't say, well, at some stage they may get round to it, and then you'll have your remedy. One respectfully submits that the issue of whether there would be an effective remedy in Romania raises the issue of whether there be a flagrant denial of justice in the absence of it, in the particular circumstances of this case, where we have the very powerful judicial finding that it may well be true that the judge was biased and corrupt.
Something slightly unattractive about the concept of the respondent saying, well, there is no remedy in Romania, and therefore don't return me, but not, in fact, actually bringing an appeal in Romania in order to test the matter.
My Lord,
it might be terribly naive of me, but what's preventing him from doing so?
Well, my Lord, what you have is you have the 521/2019, which was wrongful conviction, which Mr. Bogdan Mică presented, and that was an allegation in which he sought to show that the illegality, my Lord, the illegality was the splitting, but that there was a subjective reason for it.
But there's new evidence that you could put before the High Court in Romania, and you choose not to do so.
Well, that's, my Lord, because there's no mechanism. I mean,
well, you can't find that out until you try.
Well, my Lord, that is the view of all the experts, and it was until March. It was the view of the other side. There is no remedy. was the view of Professor Chiritza. To the extent that it was possible, Mr. Miku did try. He tried to extend, perhaps somewhat creatively, he tried to extend his complaint about wrongful conviction by reason of the severance of the case, and you've got that all in Supplementary Bundle 1, by saying, well, the reason why he did that may have been biased because of these witnesses. So everything that could be done in our respectful submission has been done. That's to say, the attempt to introduce this evidence into 521/2019. But, my Lord, where the evidence is that there is no remedy, and where that is the view that Professor Chiritza, who's obviously advising the defence as well as the court, takes, then, my Lord, we respectfully submit that it's impossible to say that the absence of a remedy is not a real and profound issue in this case. And, my Lord, we say Mr. Popoviciu has tried all the different avenues. He's got a case before the European Court. He's sought to extend 521/2019. That's run into the ground because SIJ has been disbanded and no more cases are developing. My Lord, we say that there simply is no remedy. My Lord, that is our respectful submission.
Yes, I mean, the advice that your client is receiving from his expert in Romania is that there is no remedy.
Well, my Lord, yes, and obviously it does seem very strange, and therefore one is constantly saying, is that right? But that was both the position of the government and the position of Professor Chiritza.
Yes, until the 26th of March or whatever.
Yes, and the only way would be by getting this conviction. The conviction would have to be for perverting the course of justice in this case, and then you could go under 4531D. But since the attempt to get the conviction has run into the ground with the SIJ being disbanded, the cases being reallocated and nothing further happening, see Mr. Bogdan statement, we say that Mr. Popoviciu has done everything he possibly could, both in Europe and there, and that, the remedy lies here, or the remedy may have to lie. My Lord, that's as good as it gets, but those are my respectful submissions.
Fitzgerald, thank you very much.
Thank you.
Yes, Mr.
My Lord, the respondent's first submission that the correct standard of proof is real risk obviously supposes that is what the High Court did and said. Throughout his submissions, Mr. Fitzgerald repeatedly reminded you that the finding of the High Court was that the trial may well have been unfair. Paragraph 162. He said exactly the same thing in respect of paragraph 167. That is indeed what the High Court did. May well have been is shorthand for real risk. Real risk was treated as the fact to be proved, not the standard of proof. That was substantial grounds for believing, and that reflects entirely the test directed by the High Court at paragraph 154. That is an unambiguous error. Suring and Drodst are, as are all the cases that have cited them since, absolutely clear as to the fact to be proved. Was the trial unfair? Is the trial unfair? On the dubious assumption, however, that real risk was being used by the High Court as a standard of proof, we discerned seven essential points that my learned friend raised in support of his argument for real risk as a standard of proof. The first was the bold assertion that Hoffman is the only case in which Strasbourg has addressed standard of proof for past facts. Simply not true.
Only successful.
True it is that Suring, Drodds and Wilcox don't directly address standard of proof, but none, of course, say real risk, as my Lord Stevens observed. But it's not true that Othman is the only case that has looked at the issue of standard of proof. Look at Shamayev, paragraph 338, extradition case, looking at past facts, standard of proof beyond reasonable doubt. 338. We looked at it before. It's my Lord's page 4903, Shamayev 338. And again at 353, where they apply it, my Lord's page 4907. They say in terms, standard of proof for past facts in an extradition case is the normal beyond reasonable doubt. And the Court of Appeal in this country has taken Shamayev and held that it is direct authority for the proposition that past facts need proving beyond reasonable doubt. Can I show my Lords just briefly A.S. Libya? And it's Sir Anthony Clark, as he then was, at paragraph 62 to 63, my Lord's page 2921. I don't have a huge amount of time to deal with this now, but can I invite my Lords, in due course, to pay close attention to paragraph 61 and 62. The concept of beyond reasonable doubt said the Court of Appeal has no part to play in accusation cases where you're looking at real risk of a future event. However, middle of page paragraph 61, so far as some of the cases refer to proof beyond reasonable doubt, with one possible exception, that's of course torture, they're not saying that it must be beyond reasonable doubt that the deportee will be tortured on return. Of course that's right, that's real risk, that's future looking. Only that, and these are the important words, where it is alleged that there has been an historical breach of Article 3, in assessing the evidence relating to the proof of that breach, the court applies the standard of proof beyond reasonable doubt. Authority, see Shamayev. And then at 62. Shamayev says, mere possibility of ill treatment, not enough. And then paragraph 353 is quoted, we do not think that in that passage the court could have intended to alter the principles which apply in an accusation case. Read in context, we think that the reference beyond reasonable doubt was a reference back to the discussion at 338, where, as just stated, the court was focusing on circumstances where it is alleged that there has been breaches of Article 3, historical breaches, which may of course be relevant to the assessment of risk, must be proved beyond reasonable doubt as defined by the Strasbourg Court. It's not true to submit that Othman is the only authority at Strasbourg level that has looked at standard of proof as it applies to past fact. And Lezon and Kaderli say exactly the same thing, even without reference back to Shamayev. There is a wealth of authority that supports the proposition that past fact needs to be proved in the Strasbourg sense beyond reasonable doubt, as we would understand that phrase, balance of probabilities. Secondly, my learned friend, sticking with the notion that the only relevant case is Othman, submitted that the guiding force behind that case, and therefore the standard of proof for past facts, was the mere gravity of what is being alleged. He says the magnitude of an allegation is the same, whether you're talking about something that's happened in the past or might happen in the future. Maybe. But the ability to prove that that event happened in the past is not comparable to prophesizing, or the exercise of prophesizing about whether it might happen in the future. See Mallet, see Hodson, and this isn't some quaint civil law principle. See Fernandez in the extradition context particularly. Thirdly, he says, well, judicial independence allegations are equally grave as torture and therefore should attract the same standard of proof as Hoffman thought was appropriate for torture. Of course, the truth is more nuanced than that. Multiple cases remind us that judicial independence covers a wide gamut of factors, some of which are flagrant, some of which are not. All depends on the application of the legal standard for judicial independence, the second stage of the Porter and McGill test, against the core facts found. But Mr. Fitzgerald's submission went on, where, he says, an allegation is of a breach of something that is flagrant, then for that reason, a lower standard of proof should be engaged. On this theory, standard of proof is determined by the nature of the allegation, not the cogency of the evidence required to support it. The tail is wagging the dog. It's a circular submission which assumes that which it seeks to prove, namely that the allegation is true. An allegation isn't credible just because it's serious. If anything, the opposite is true. The more serious the allegation, the greater the cogency of evidence which ought to be required to prove it. Fourth, Mr. Fitzgerald then moved on to domestic bias cases, which he claimed operate a may well have been approach to proof of underlying facts. Not true. As my Lord Stevens observed, the circumstances in Porter and McGill cases are always established on the balance of probabilities. And that's no quaint civil rule either. Precisely the same thing is true in the criminal context. I hope they have arrived, but there is a batch of other cases that we have in hard copy, because we're not entirely sure that they would have arrived in time. But my lords should have had a batch of cases that include Merzer, Young, and Fage.
We have them through an email at 10:48 this morning.
Well, that's...
Should be
I'm not going to engage with how that happened, my lord, but we brought hard copies. We were then told that wasn't the right way. So my lords have them.
Yes, I'll have to find them. If you've got hard copies,
yes, we do, my lord. I wonder
we do tend now to work from electronic papers, but if there are last minute
there's 10 sets there.
Lodgings and they are in paper form, we'll take them.
So I want, if I may, to scotch this idea that the underlying facts in a bias case can be shown by something like may well have been right or could be right. Or the first amongst the cases that we adduce is Merzer, please. Case of this court. This court as it once used to be, back in 2004, concerned with juries in which the majority held that the secrecy rule for jury deliberations prevents any inquiry into what happened in the jury room. Undeterred, my learned friend sought to persuade this court, and this is paragraph 113, I think is the easiest way into all of this, because most of this judgment is concerned about the power of inquiry. 113, in Lord Hope's judgment, top of the page, which should be numbered page 1162.
Yes.
My learned friend sought to submit, even if we can't inquire into what happened, it is sufficient for there to be, and you see this fourth line down, an allegation capable of belief, which when fed into the legal test for bias, would cast doubt on the safety of the conviction. But Lord Hope addresses that suggestion at paragraphs 117 to 118, because Lord Steyne was interested in the idea. But the point is, see the middle of 117, it assumes that the allegations which the juror makes are the subject of cogent and compelling evidence. It takes at face value, without any further inquiry, that there are sufficient grounds for holding that the bias test, real risk, is satisfied. Paragraph 118, if this approach is sound, unnecessary for the jurors to be interviewed at all. There wouldn't need to be an inquiry. All the courts need to do is examine the letter of complaint. It need only ask itself whether it contains a cogent and compelling allegation demonstrating a real risk that the jury was not impartial. If the allegation measures up to that standard, the verdict will be set aside. It's a simple solution, but it's unacceptable. An allegation, however articulate and however provocative, is no more than an allegation. It cannot be assumed that the facts it alleges are true. To do so would be to upset every verdict at the mercy of malicious and the unscrupulous. At the very least, the allegation must be checked to see whether there are good grounds for believing that what is alleged to have happened really did happen. How else can one assess whether it provides cogent and compelling evidence? Lord Roger was of a same mind. See paragraph 171. Paragraph 171. I invite you to read it in due course. Lord Slynn was of a same mind. See paragraph 54. The fact is, allegations are only allegations until they are proven to be true. And that is the core finding of Merzer. We were therefore a little surprised to hear Mr. Fitzgerald suggesting yesterday that there are cases that adopt a different view, where something that just may well have been true is being acted on by criminal courts, and the Court of Appeal in particular, in jury cases. So we looked at his Ouija board example case. It's Young, which you should also have in your materials. What happened in that case is now infamous, but it prompted, and this is the important aspect for our purposes, the Court of Appeal to engage a full-scale inquiry into what had happened in that hotel room where the jurors were sequestered. The result of that inquiry, see page 334C, was establishment so that there could be no doubt, see line 4 of that paragraph, that the jurors had been playing with a Ouija board. The Court of Appeal didn't interfere on a mere basis that the séance may have happened. They satisfied themselves, in fact beyond reasonable doubt in the way we understand it, but they satisfied themselves after an inquiry that it had happened. And then, in the way of all these things, they fed those proven facts into the machinery of the legal test for bias. Did it disclose, in a legally evaluative sense, a real danger? And the answer was easy and obvious: yes, it did. But Mr. Fitzgerald is wrong to suggest that there is authority here for the proposition that the Court of Appeal would interfere on the basis of a merely may have happened event. And the same, as my Lord Stevens has observed, is absolutely true of his Brown case. What the Court of Appeal acted on in that case, see paragraph 36, was the fact that the jurors could be shown as a matter of fact to have taken against the defendant. Whether they were justified in doing so by reference to what had happened in the canteen, was a complete irrelevance. The fact, which then had to be fed into the machinery of the legal test of bias, was that it was clear that they had taken against the defendant. There's nothing revelatory in that unreported and probably extempore decision by Lord Mance, as he then was. I rather suspect Lord Mance would be as surprised as anybody to hear that it's being put forward as some radical new decision on the appropriate standard of proof for past fact. None of these cases, indeed no case at all, provides any basis to suggest that the fact-finding exercise in a bias case is diluted so far as the standard of proof is concerned. And there's no particular autonomous Strasbourg principles in play here which could dictate a different outcome, because we're in the realms of Article 6. To be clear, the course, the legal test for bias contains an element of legal evaluation. Most legal tests do. Flagrancy is another example, but that's not the kind of evaluative exercise that Pearce is talking about. Pearce is talking about past facts which inform a subsequent factual evaluation, not past facts which inform or to which legal evaluation is then undertaken, such as gross negligence. Those facts always have to be proved to the requisite standard of proof because they are the facts in issue, and the standard of proof is always balance of probabilities, just as it is in bias cases. So bias doesn't help us at all. Fifthly, my learned friend then cited Othman for the proposition that the standard of proof is whatever can be fairly imposed. That's not what Othman says at all. What Othman says is, in the unique torture context, for all the reasons we've explored, which apply only in that context, real risk is the only standard of proof which can be fairly imposed. Extrapolating that out as a general principle that judges can and should select whatever standard of proof they think fair, in any case, is recipe for chaos, or at least unprincipled decision making. And, as my learned friend ignores, it's precisely what Othman itself warns against. See paragraph 265. 265.
Sorry, the page number for that?
Of Othman, page 265. Can I come back to that, my
Certainly,
Lord?
yes. No, don't take it.
Sixthly, then, Mr. Fitzgerald finally sought to engage with the actual reasoning in Othman at paragraph 276. Remember, that's where it talks about statewide complicity in the practice of torture. And suggested, well, that's simply an example of a defendant making allegations which are difficult to prove. And the standard of proof should therefore be culled, he says, in all cases where an allegation is difficult to prove. And he used that as a springboard to launch a series of submissions which collapsed the Strasbourg treatment of inferences into its treatment of the standard of proof. And this is where the rot really set in. We have seen that outside torture, beyond reasonable doubt, is the standard of proof that Strasbourg applies. It does so across the board, Articles 2 through to 18, and it does so rigidly. We have also seen that Strasbourg allows those who claim a breach of any of those articles to raise inferences against the state as evidence to help them satisfy that standard of proof. We have seen that Strasbourg develops coherent rules about how that should work. Prima facie allegations, shifting onuses to explain, concordant inferences, all of those words and language reflect an exercise which is entirely familiar with courts up and down the country. What Mr. Fitzgerald did was take all of those prima facie allegations, shifting onus to explain, concordance, etc., and employ it as if it was being used by Strasbourg to describe not inferences, but the ultimate standard of proof. And that's precisely what Strasbourg does not and has never done. You could look at any of the authorities that talk about beyond reasonable doubt for this, but let's please just look at one so that we can see it in operation. It's one of the respondent's two favourite cases. It's called Bakker. At page 4008, you will find paragraph 143.
Paragraph
143.
Thank you.
Page 4008. Mr. Fitzgerald went to it, and he began about 2/3 of the way through paragraph 143 with the quotation about flexibility of the court's practice.
Yes, you're referring to the sentence 8 lines down.
Absolutely. You need to read this as a whole. The standard of proof is rigid. The operation of inferences is what attracts the kind of language that Mr. Fitzgerald was seeking to employ. There's nothing in the Strasbourg case law concerning inferences which assists Mr. Fitzgerald in trying to shift the standard of proof. And then seventhly, Rostas. Mr. Fitzgerald accepts that Rostas has misinterpreted Othman paragraph 261. He has thereby lost the foundational force of the only authority that supports what he says and the only authority upon which the High Court acted. His new suggestion is that there may be other bits of Othman that could support what Rostas did, founders on different reasons, because that's to do with torture. In sum, the respondent's case, in his attempt to support the High Court's approach on the standard of proof, must fail. So the bulk of his submissions were therefore predictably directed to his first fallback, that if he's wrong about the standard of proof, and it was in fact the balance of probabilities, this court should substitute its own view of the facts for the clear conclusion of Lord Justice Holroyd at paragraph 162 that standard was not met on the evidence. That might be thought to be a startling submission to make before this court. Lord Justice Holroyd is one of the most experienced criminal judges in this country. He presided over this case for 5 whole days. He had days of deep exploration of materials and evidence concerning Judge Tudoran's retirement, his substantive handling of the civil case, which, by the way, was upheld as entirely correct by the Romanian Supreme Court, about the precise circumstances in which he came to deliver his ruling. The High Court was aware of all of that, the whole sea of evidence, not just the island hopping in which an appeal court is necessarily engaged. It heard live evidence from the sole witness that the respondent was prepared to expose to cross-examination. Paragraph 160 of Lord Justice Holroyd's decision is excoriating in respect of that witness. According to the High Court, having seen him live, he's a witness implicated in immoral and inappropriate behaviour, giving hearsay evidence by and large, whose evidence is unconvincing, incredible, tailored. Those are not words that a criminal court uses lightly. I could flesh out and explain why Mr. Dejana was such an atrocious witness. But to do so would
paragraph are you referring to?
160 of the High Court.
Oh, yeah.
That's their assessment of Mr. Dejana as a witness of truth. I could give you a whole host of reasons why that was an entirely appropriate factual conclusion to bring. He had a motive to lie. His evidence was vague and uncorroborated. It was largely based on scuttlebutt and rumour, selective rumour at that, omitting all references to bits of the story that didn't support his thesis. It was a thesis that was in any event entirely inconsistent with what actually happened at the trial when Mr. Begali tried to resile from his evidence against Mr. Popoviciu. Why do that if they're in cahoots? There was a witness who remained silent throughout the whole of this trial, 2013 to 2016, whose explanation for remaining silent was incredible.
I'm not sure if this court can go behind paragraph 160. So
well, that's my point with respect.
You're fleshing out a bit. I'm not sure it was as...
Well, I'm relieved to hear it, my lord, because I don't have a huge amount of time. But my essential point is you haven't heard the witness that Lord Justice Holroyd heard. You can't substitute your own view of his credibility, and the suggestion that you can is extraordinary. The other authority in the batch, the small clip that you have, is, and I'm sure my lords will be entirely familiar with
a familiar case.
Age, the Greek yogurt case. Paragraph 114. I know my Lord Kitchen will be entirely familiar with it. A memorable exposition of why it is that the appeal court shows proper reluctance not to engage in the kind of substitution of its own views on issues of fact for the trial court. Trial court had the sea of evidence. You're only island hopping. You can't recreate the atmosphere of the court. All of it. All of those are cogent reasons, powerfully summarised for why you cannot engage in the kind of exercise that Mr. Fitzgerald invites you to. And equally extraordinary is the suggestion that you should substitute your own views for Lord Justice Holroyd's overall evidential evaluation. Paragraph 163 explains in clear terms that Lord Justice Holroyd took a dim view of Romania's evidential response to all of this. You know my case. My case is that wasn't really justified. If you look at the whole document, that's not really fair. But I have to accept that that is the view that Lord Justice Holroyd took. And he took that into account in his overall assessment, which culminates with the conclusions at paragraph 167. His overall assessment was, however, that taking it all together, it hadn't been proved on the balance of probabilities that a judge in Romania of 40 years standing in a friendly EU member state had been shown to be criminally corrupt. That was a pure question of fact to be answered by an equally experienced criminal judge in this jurisdiction on the basis of the live evidence he had heard. How, with respect, can you begin to substitute your own view for that? How can you begin to substitute your own view about the quality or the weight you should apply to inferences in this case? Inferences differ entirely in the weight that should be given to them. My Lord Hodge observed there's a world of difference between an inference in the way that Strasbourg is talking about of facts which are within the state's knowledge, which it has failed to explain, and from which it can therefore be inferred it knows to be true. That's a weighty inference. That's not the type of criticism that's levelled against Romania at paragraph 163. The criticism there is that they really should have investigated all of this. to the variable weight that applies to any given inference, if that's what paragraph 163 can fairly be described at, is then set the weight carried by the remainder of the evidence. Rubbish evidence, which raises maybe a 5% chance that it might actually be true on Mr. Fitzgerald's scale, would require truly weighty inference to drag it up to 51%. On the other hand, pretty decent evidence, 40%, would by contrast require a mere leg up. How can you possibly say that Lord Justice Holroyd's evaluation of those respective weights, where it all fell on the evidence he heard, was wrong? Fact is, I could mount a decent argument that Lord Justice Holroyd was entirely too accommodating of the respondent. Opris's evidence was taken into account, notwithstanding that he hadn't actually given a statement at all. All there was a complaint he'd made in different proceedings, wasn't even on oath. And yet the court must have inferred in the respondent's favour that he was nonetheless prepared to stand by that in these proceedings. Well, that was a bit generous, wasn't it? What about Mr. Dumitrescu? He was one of those witnesses who wasn't prepared to give live evidence in these proceedings at all or be cross-examined. No application at any stage for him or anybody other than Mr. Dujana to give live evidence. And yet the court admitted his written statement, took it into account, and therefore must have inferred that there was some sensible reason for him not wanting to give live evidence, despite Mr. Dujana never suggesting such a thing, and despite Mr. Dumitrescu never suggesting such a thing. The fact is, what happened in that 5-day hearing is impossible now to recreate. And unless you can recreate it properly, you can't begin, with respect, to entertain the kind of factual submission that Mr. Fitzgerald was engaged in about the weight to be afforded to witnesses, the weight to be afforded to inferences, why it is, whether it was fair or not, to have regard to one bit of evidence and not the other. So what about Mr. Fitzgerald's second fallback case, his Article 5.4 case on the absence of future remedy? This is, to be clear, and I say this because of what's been written in Mr. Fitzgerald's fourth skeleton argument this morning, this is entirely devoid of merit. My lords know my case that Article 5.4 wasn't mentioned once in the proceedings below in any of the 200 pages of skeletons.
My understanding is this court has got to comply with the convention, and whether it was or wasn't mentioned may be of some significance, but all the same.
So be it.
And I also understood you to be accepting that Article 5.4 required there to be a remedy in Romania. And
I accept Article 5.4 requires there to be a remedy for fresh circumstances in the Weeks Todorov sense. Our case, if this is, and I take my lord's point that these are human rights and so perhaps shouldn't be shut out on the fact that you've raised it too late. Our case is firstly, the area of agreement that exists between the experts is sufficient. Sorry, I've probably turned away from the... So I accept my lord's point that we're talking about human rights, so perhaps it's too austere to shut out Mr. Fitzgerald on the basis that he should have argued it below. Fair enough. But he still has to confront...
That's a sensible concession.
Sorry? He still has to confront the fact that there is agreement between the experts that there is a remedy available. Article 20 of the Constitution, and it's a bit difficult with respect to see how he can say, well, it's not a very good remedy in circumstances where he hasn't even tried it.
Well, there is not agreement that it is, in Strasbourg terms, an effective remedy.
That's because he hasn't tried it.
That, in one view, would be enough to suggest that the question of a remedy for weeks-like circumstances is something that has not yet been covered by the proceedings.
I know my lord knows our case on this. There is a remedy, and until you've tried it, how can you say it's not effective? But the fact is, even if the court doesn't agree with that analysis, over the course of 6 years, the UK courts have listened carefully to every single Article 6 complaint that the respondent has made. It's difficult at times to remember that this is a European arrest warrant case. It should be turned around, I think, in 30 days. It's occupied the court even before it stalled in the High Court through their wrong approach to the standard of proof. It had occupied the courts for 4 years. That's the Specialist Extradition Court and then the High Court, who entertained...
But it still hits the buffers that we cannot act contrary to the Convention.
And I don't invite my lord to at all. What I'm saying is that the Convention has been complied with by the review that these courts have undertaken. They've entertained, they've listened to, they've examined all of his various complaints under Article 6, that the President had directed his prosecution, that the Supreme Court of Romania was corrupt, that the intelligence services were behind it all, that the prosecutor was corrupt. All of it, including the new 11th hour suggestion that the judge himself was corrupt, has been examined by courts in this jurisdiction with full jurisdiction, with the power to hear any witness, with the power to look at any materials, with the power to draw any inferences, and applying precisely the same flagrancy test that would be required in any 5.4 review hearing, see Hamilton. It's examined it all. It's done so for years with admirable patience, and it's found it in the end to either be rank speculation, see judgment paragraph 156, or, so far as the latest iteration is concerned, not proven to the standard of proof. That is, with respect, the very epitome of an Article 5.4 examination of the legality of detention. What else could a court do in Strasbourg human rights terms, Article 5 terms, beyond what has been done for 6 years in the courts of this jurisdiction?
Well, the point that interested me, and it is perhaps a totally inappropriate suggestion, but if the case was to be remitted under Article 5.4, whether a term can be imposed or a condition can be imposed that the applicant actually makes an appeal to the High Court in Romania. And, so that rather than trying to defeat his extradition, he actually tries to secure his retrial.
But therein lies the strength of my first submission, which is there is a remedy in Romania. Yep. There we are. Can I just, and I've got 3 minutes, deal with the suggestion, the fourth fallback. If you're against Mr. Fitzgerald on the standard of proof, you're not minded to substitute your own view of the facts for those of the High Court, and you think he has had an Article 5.4 hearing in reality, what about his last fallback submission that you should nevertheless remit to the High Court so he can have another attempt to establish on the balance of probabilities that his trial was unfair by reference to new evidence? And the answer to that is that none of this evidence is remotely new, or in fact different from the body of evidence that he deployed before the High Court. My lords, I know, are entirely familiar with the Fenivesi principles for fresh evidence. They were approved by this court in Zabolotny and don't need repeating. The fact is, these new witnesses were witnesses with whom the respondent was in contact at the time of the High Court hearing. If he wanted to call them, he could and should have done. Can I just finally refer you to the evidence which makes that proposition good? My Lords, please, electronic page 5735. This is the evidence that this is how it all started, actually. The evidence of Mr. Cioccan, a journalist in Romania who had been following the Cesar Panet inquiry and started to feed all of that into these proceedings. Paragraph 37 at page 5735 he makes clear that he has been speaking as at the date of this statement, September 2020, so 6 months before the High Court appeal hearing.
The date was
September 2020, this statement is dated 6 months before the High Court hearing. Paragraph 37 on page 5735, he had been personally speaking to Mr. Opris. So what explanation is there for not adducing Mr. Opris's statement in the High Court? It hasn't just come to the attention of the respondent that Mr. Opris might be prepared to give evidence. And what about the other new witness, Mr. Andronich? Is he genuinely new? Is it right to say that he only came to everybody's attention a few weeks ago?
No, before the hearing.
Look at paragraph 41 on page 5736. The respondent's own witness, Mr. Cioccan, had assisted Mr. Andronich in the giving of his testimony in Romania back in August 2020. He isn't somebody who's just come out of the woodwork, whom the respondent had no idea existed at the time of the High Court's hearing in March 2021. All of this so-called fresh evidence was, with reasonable diligence, known to the respondent at the time of the High Court hearing, could and should have been obtained then, not now, and fails entirely the Fenovesi-Zabolotny test for the admission of fresh evidence, such as to found Mr. Fitzgerald's last fallback submission that he should be allowed to have another go to convince Lord Justice Holroyd about the balance of probabilities based on fresh evidence. This isn't fresh evidence at all. My Lord. Thank you. My Lord, Lord Richards asked for the references to Othman, paragraph 265. It is page 2605. My Lords, unless I can assist further, that is our reply.
Thank you very much. The Court is very grateful to counsel for their submissions in this case, and also to those who have assisted counsel in the preparation of their submissions and also in the preparation of the documents which we have seen and will have to consider. The Court will take time to consider its determination of this important appeal. The Court will now adjourn. That's a point. If parties wish to put in a note about weeks and such case law, could that be done within 14 days?
Yes, my lord.
Yeah.
Thank you. Of course.
Yes. Well, given that it has emerged as an issue in this appeal, I think notes from both parties on their position on those cases would be helpful to the court. I'm grateful to Mr. Fitzgerald for reminding me.
My learned junior who prompted me. I'm so sorry, my lord.
The court will now adjourn.